हाँ भाई, तो आर्टिकल 19 देखना बाकी था, तो आर्टिकल 19 देख लेते हैं एक बार. What the Article 19 says, let's read first, then we will discuss about the Article 19. So Article 19 says that protection of rights regarding freedom of speech. So basically, right to freedom, it deals. So takes the, it gives the right to the citizens that all citizens shall have the right to freedom of speech and expression, to assemble peacefully without arms, to form association or union or cooperative societies, to move freely throughout the territory of India, to reside and settle in any part of territory of India. So basically Article 19 has 6 clauses. Article 19 1A, Article 19 1B, Article 19 1C, and Article 19 1D, and Article 19 1E, and Article 19 1F. So basically Article 19 1A deals with freedom of speech and expression. Article 19 1B deals with right to assemble peacefully. Right to assemble peacefully without arms. In Article 19B, Article 19C talks about right to form association. Association, union, or cooperative societies, and Article 19(1)(d) talks about right to movement throughout the territory of India, and Article 19(1)(e) talks about right to reside anywhere in territory of India, in any part of India. And Article 19(1)(e) talks about right to do business or occupation throughout the territory of India. Throughout territory of India. But remember one thing, these all rights which is given to the citizen of India are not purely independent. They are all these rights come with some restrictions, and for the restrictions of Article 19(1)(a), the restrictions ground has been mentioned in Article 19(2). For Article 19(1)(b), that is right to assemble peacefully without arms, these restrictions have been mentioned in Article 19(3). And for right to form association on these behalf, restrictions ground have been mentioned in Article 19(4). And for right to movement throughout the territory of India and right to reside in any part of India is also restricted. Both are restricted on the ground which are mentioned in Article 19(5). And right to do business occupation throughout territory of India are also restricted on the ground which has been mentioned in Article 19(6) of the Constitution of India. So basically Article 19(1)(a), it talks about freedom of speech and expression of any citizen. Article 19(1)(b), which talks about right to assemble peacefully. Article 19(1)(c) talks about right to form association, union, cooperative societies, but its restrictions ground has been mentioned in Article 19(4), on which it can be restricted. Now, Article 19(1)(d) talks about right to movement throughout the territory of India, and Article 19(1)(e) talks about right to reside, right to live in any part of territory of India, and both Article 19(1)(d), Article 19(1)(e) are restricted on the ground which has been mentioned in Article 19(5). And Article 19(1)(f) says that right to do business occupation throughout the territory of India has been restricted on the ground which has been mentioned in Article 19.6. These are the articles which has been mentioned in Article 19 of the Constitution of India. So let's first talk about Article 19(1)(a) in detail, which talks about freedom of speech and expression of any citizen of India. So now let's talk about Article 19(1)(a). What the Article 19(1)(a) says that freedom of speech and expression. Now, it's not basically to express something and speak something it's mentioned in the Article 19, but these restrictions ground mentioned in Article 19(2) of the Constitution of India. Now first read Article 19(1)(a). Article 19(1)(a) says that all citizens shall have the right to freedom of speech and expression. So basically, it talks about freedom of speech and expression on it taken away from the Irish Constitution. Now let's read it in detail. What do we mean by freedom of speech and expression? So we can express ourselves by word, we can express ourselves by written, we can express myself by orally, in whatever way we can express myself. So now plus Supreme Court also expanded the definition of freedom of speech and expression. Let's discuss on that in various cases. So freedom of speech and expression includes that you can express yourself by word, by written, by orally, and also Supreme Court stated that in its very judgment that freedom of speech also includes to express by art, by gesture, by sign, by symbol, by painting, etc. On whatever way you can express yourself, it will be considered as freedom of speech and expression. Now, in the various judgments, Supreme Court also stated that freedom of press is also considered under Article 1(a). In the various case, in the case of Sakal Paper versus Union of India, Supreme Court stated its judgment. Basically, what had happened, it's need not to be no compulsory, but I will tell you that in the Sakal Paper case, what has been happened that our government has restricted on the news agencies to purchase a printing paper. So basically, you can't purchase a paper more than that limit. So in this case, Sakal Union of India Supreme Court stated that you can't restrict on the paper limit because for the news agencies, the advertisements is the only source of their income. So if you are restricting them, for not allowing them more paper, for not allowing them to purchase more paper, then basically you are restricting their economy. And if you are restricting their economy, then also you are restricting their independence. And if you are restricting their independence, then basically means you are restricting their freedom of speech and expression to express their self in the written form. So that's the basically case in which Supreme Court stated that freedom of press is also a part of Article 19(1)(a), that is freedom of speech and expression. Now, In another case, known as Genova Witness case, Supreme Court stated that right to remain silent is also a part of freedom of speech and expression. Basically, what has been happened, there is a person who is not singing the national anthem while praying the national anthem. So this case has been gone to the Supreme Court, and but that person is not disrespect, only not singing, but this person is not disrespecting the national anthem. So the case has been gone to Supreme Court, and Supreme Court stated the right to remain silence is also a part of freedom of speech and expression. Basically, if you are not singing the national anthem, but you should not disrespect the national anthem. If you are disrespecting, then it is a violence. But if you are not disrespecting and you are not singing national anthem, then it's okay. Because right to remain silent is also a part of freedom of speech and expression. Now, in the another case, Supreme Court also stated right to hoist national flag is also a part of freedom of speech and expression. Because what the case has been happened in Naveen Jindal case. Naveen Jindal is the very dignitary person. He says that why only on the 26 January and 15 August should be the day for hoisting the flag. It's my country, it's my choice, it's independence of mine that I can hoist the flag in any time, in any time on my house. So basically, it's my right to hoist the fundamental. It's my right under fundamental Article 19(1)(a) to hoist the national flag. Now, in another case, Supreme Court stated right to no criminal and economic background of candidate contesting election. So basically, you have the right to know criminal and economic background of the candidate who is going to contest the election. And Supreme Court also stated right to freedom of speech. Also, it can also be done by the modern mean of communication. So basically, modern mean of communication is also a part of freedom of speech and expression. Now, these are the various forms on which freedom of speech and expression in any other forms also as well. You can express yourself and it will be considered as freedom of speech and expression. Now, now, Article 19(1)(a) is not a completely vague in nature. It can also be restricted on the Article 19(2). Article 19(2) grounds mentioned on which Article 19(1)(a) restricted. So what are the ground has been mentioned? Let's read first, then we will discuss about. So let's read in the Constitution. So Article 19(2) says that nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state for making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the state subclause in the interest of sovereignty. Basically, what are the grounds which has been mentioned? First is sovereignty and integrity of India. And what is the another ground? Security of state, security of state, friendly relations with, friendly relation with foreigner, foreign state, public order, decency or morality, and contempt of court, COC, contempt of code, defamation, and incitement to offense. So basically, these are the grounds which has been mentioned in the Article 19.2 on which Article 19.1a can be restricted. What are these grounds? Sovereignty and integrity of India, security of state, public order, morality and decency, or security and contempt of court, defamation, incitement to an offense. Now, Article by the first Constitutional Amendment Act, reasonable word has been added. So therefore, now reasonable word has been added by the first Constitutional Amendment Act by the Parliament. Now, first discuss these one by one grounds in detail. As we have discussed that, as we have discussed earlier, so it has been added by the 16th Constitutional Amendment Act. And public order, incitement to an offense, this, this, and this has been added by first Constitutional Amendment Act. Okay, so now let's read one by one. Let's read one by one. So first discuss about the sovereignty. We know what is the sovereignty and integrity of India. If you are speaking which affect the sovereignty and integrity of India, then it will be a ground for violating your fundamental right. And if any law, if any speech, if any written form, if any gesture, if any uh, other form, if you will speak, if you will express yourself, which affect the security of India, then it will also be a ground on restricting your fundamental right. And if any law, if any speech, if any written form, if any article which affect the friendly relation with the foreign states, then it can also be a ground on which it can be restricted your fundamental right. And public order, basically public order has been added by the first Constitutional Amendment Act because because there is a person who published his article and led to a disturbance of the public order. So if you are publishing article or if you are giving a speech which can affect the public order, then it can also be a ground on which your fundamental right can be restricted. Now, what do we mean by decency and morality? Decency, morality basically means that if you are expressing yourself by the art form, by another form, and if it is very obscene, that it cannot be seen in the public place, in it cannot be seen in the morally correct. It is not morally correct. Then it can be restricted on the fundamental right. But let's discuss more on the decency and morality. Basically, any obscene scene which made for sexual arousal then it can be restricted on fundamental. It can be restricted on the ground which has been mentioned in the decency and morality. But remember one thing, Supreme Court also stated, because there is a picture which has been made by uh, I have forgot the name, but he is the decade, or I don't know. He's the decade. I think I have forgot the name. And the 1 minute, I should search. Then I will. Phulan Devi. So basically, Phulan Devi, the movie has been made on the Phulan Devi, and in this movie, they shows how Phulan Devi becomes the dacoit. What are the circumstances? What are the situations on which Phulan Devi has to compel to become a dacoit? So, to represent this Phulan, to represent this scene has been represented in the movie without clothes. So this matter has been gone to Supreme Court that it's violating the decency and morality of the Constitution of India, which has been mentioned in Article 19(2). So Supreme Court stated that this scene has not been made for the any sexual arousal. This scene has been made for to convey a message that why any person has become decay. So Supreme Court stated that if your intention is not, basically Supreme Court stated your intention should be right. If you are making any scene with the sexual pleasure, then it's not okay. But if you are making any scene which to convey a message, which to convey a message to the society that why this person has become the dacoit, then it's okay. And also Supreme Court stated that you can't make any such scene which cannot be seen in the public place. So what decency and morality definition we have seen that Supreme Court stated that you can make a scene which can be obscene, but it should not be made for any other purpose. Basically, it should be made on the purpose of to convey a message to representing someone's dignity life, why this person has become a such criminal or such persons after facing such some problems. Now we have discussed security of state, sovereignty and integrity of India, friendly relations with foreign states, decency and morality, public order. Now, incitement to an offense is basically if you are speaking or publishing an article or doing something which can lead to an offense. Basically, let's suppose you are a person and you have there is another person and you have given him such motivation that he has killed any person. Basically, I have incited to that person to do this crime and he has done this crime. Then it is also a offense. So basically, if you are pushing someone to do an offense, then it will also be a ground on restricting your fundamental right under Article 19(1)(a). Sorry, Article 19(1)(a). Now, we have discussed incitement to an offense, decency and morality, public order, friendly relation with foreign states, security and sovereignty and integrity, security of state. Now let's discuss in detail about the contempt of court proceeding. What do we mean by contempt of court proceedings? and let us discuss about also about the defamation. So we have discussed about the public order, we have discussed about the incitement to an offense, we have discussed about the security and security integrity of India, we have discussed about the fundamental relation with the state, we have discussed about the society of security of India, we have discussed about the decency and morality. Obscene content cannot publish, or if you are published then it should be to give message, not for the sexual pleasure. So basically, and Supreme Court also stated that morality to be did and morality basically Supreme Court also stated that because by the time and time, if you have seen in the 90s era, kissing scene is very prohibited in the scene. So now it's okay. So Supreme Court said time to time the decency and morality will be decided by the Supreme Court on the adult. So basically, on the time by time basis, decency and morality will vary. Plus, Supreme Court also stated we should make a scene only in such a way that it cannot affect the lowest mind people. Basically the lowest mind people basically means which are minor, age of 14, 15, 13, 10, 9, 8. So these are the child which have lower mind, which have not much understanding. So you can't make any such scene which can affect negatively to those child, to those lower mind children or to lower mind persons. So this is the basically morality and decency definitions which has been given by the Supreme Court of India. Now let's discuss two more ground has been left, that is contempt of court and defamation. So let's discuss about the contempt of court proceedings. So now what is the contempt of court? First discuss about this, then we will discuss about the defamation. So COC basically contempt of court. So what is the contempt of court? Basically, uh, if you are disrespecting or trying to disrespute the Supreme Court or High Court of India, then Supreme Court and High Court under Article 129 and under Article 215 can send you on jail, can fine on you on disrespecting the Supreme Court or the High Court of India. So basically, disrespecting or disrespecting to court. Now let's discuss more in detail what is the contempt of court proceedings. That power to punish for contempt of court is given only to High Court and Supreme Court. In High Court it has been given under Article 215 and Supreme Court it has given under Article 129. So basically, contempt to initiate the contempt of court proceeding, it can be done only by High Court or by Supreme Court. So in Article 215, let's read once 129. First read 129, then read 215. 129 of the Constitution of India. So basically Article 129 says that Supreme Court shall be a court of record. So basically Article 129 says that Supreme Court will be a court of record. We will discuss what is the court of record, and also says that Supreme Court shall be a court of record and shall have all the powers to such a court, including the power to punish contempt to itself. So basically, Supreme Court have the power to punish any persons on doing contempt against the court, and also any authority which has been lesser than Supreme Court, and you have also not followed the judgment of that, and you have violated judgment, then Supreme Court can also issue contempt of court proceeding against you. So Supreme Court have contempt of court power for itself. Basically, if you are violating the decision of the Supreme Court, then contempt of court proceedings can be started against you. But if you have violated this judgment of any authority which has lesser than Supreme Court, then Supreme Court can also issue contempt of court warrant against you. So basically, also, but for itself, but also for contempt of judiciary to other court if judgment was disrespected. Therefore, contempt of court will be issued by the Supreme Court. Now, for the High Court, Article 215 says that High Court have the contempt of court power to issue the contempt of court of violating its judgment. Basically, High Court have reached its judgment and you have not followed the judgment. Then contempt of court proceedings can be stated against you for High Court judgment for itself. And Supreme Court have also the power to issue the contempt of court on the district court, on the court which belongs to this high court region. So basically various district court belonging for the under jurisdiction of the high court, and if you have not followed the judgment of these district court, then contempt of court proceedings can be started by this high court. Basically, district court have not the power to start contempt of court proceedings. Therefore, this power has been assigned to high court, that on the behalf of district court, high court will issue the contempt of court procedures if any person not followed the judgment of the district court. So basically, and also for judiciary lie within their region. Now we have discussed Article 215 and Article 129. But what do we mean by court of record? Basically, Supreme Court have also one more power, that if he makes any decision, let's suppose on particular matter, Supreme Court gave its decision and same matter has been come in the lower court, then the judgment of the Supreme Court is binding on the lower court. So basically, whatever the judgment has been given by the Supreme Court is written in the court of record, and this court of record will be followed by lower judiciary, and Supreme Court will also follow the judgment of which has been given in the upcoming cases. And for the violating of the court of record, it can be violated by the Supreme Court only. But Supreme Court can violate the court of record by making the higher bench. Basically, let's suppose any decision has been made by the Supreme Court, and there is a bench of five judgments, and they have make a decision. This decision will be written as court of record, and this decision will be followed by lower judiciary if any case has been arisen in the future in the lower judiciary, and this judgment will be binding on the high court or the district court. And also, if itself Supreme Court wants to violate the decision of contempt court of record, then they have to make a higher judge bench. Basically, they have to make seven judge bench to violate its contempt its court of record. So that's the basically mean of court of record. Now, this has been discussed. Now, in the response of this, Parliament pass contempt of code contempt of court Act 1971. In response to this, in this act, there has been mentioned civil contempt and criminal contempt. So what is we mean by civil contempt? So civil contempt basically mean if any civil matter has been come. Let's suppose property disputes. Let's suppose marriage disputes. Let's suppose any other disputes which relates to civil matter. Then if you have not followed the judgment of the high court or the district high court and supreme court, and on the behalf of high court the judgment of district court, if you have not followed the judgment of the civil matters, then that is willful disobey of an order of court, that is plus willful disobey of undertaking given to court. Basically, if you have misrepresented the documents in the court, then civil contempt will be issued against you. But in the civil contempt, no jail or no jail punishment will be given. So basically, you will have to pay the fine only. So basically, punishment will be only fine, not anything else. But in the case of criminal contempt, it will be initiated if you are interfering, if you interfering in the procedure of in the judicial procedure. That is, if any judicial proceeding is going on and you are interfering it, then criminal contempt can be issued against you. Plus, if you are interrupting with administration of justice. So basically, if you are interrupting, if you are basically धमका के चले जाए भाई आज आप मिल लेंगे बाहर तुमको, है ना, तो ऐसा नहीं है. अगर ऐसा आप करते हैं तो criminal contempt can be initiated against you. Plus, if you have scandalized, चल भाई आजा बाहर दो पे दो खेल लेंगे. So if you are trying to scandalize the authority of court, then criminal in all these cases, criminal contempt can be issued against you by the High Court and by the Supreme Court. And if contempt, criminal contempt has been issued, then the punishment may be jail, may be fine, or both. So you can get the jail, the jail can be happen to you, imprisonment can be happen to you, or you can have to pay fine, or you can also send to the prison, or and also you have to pay the fine. But there is an exception to contempt of court. What is the exceptions? Exception is that if you had said something in the against of Supreme Court judgment and it's a valid point, or basically let's write once. Exception is that if you have criticized, if you have criticized, if you criticized judgment and criticism is fair enough, then no contempt of court proceeding will be issued against you. So, if you have criticized the judgment of any Supreme Court, of any High Court, of any District Court, but the judgment, the criticism is fair enough, then no contempt of court proceeding will be initiated against you. Now, and also innocent publication and distribution of matter related to proceeding of court. So basically, you don't come to know that whatever I have done, it will be considered as the contempt of court. So you are innocent and you have published any article which should be treated as contempt of against contempt of court, but you don't aware of it, then the court has give the relaxation to that person that if you don't know, then it's okay. I will not issue the contempt of court proceeding against you. But if you will repeat it again, then contempt of court proceeding can be initiated against you. So these are the exception which has been given against the contempt of court proceedings. Now, what is the importance for the contempt of court? Why do we need of contempt of court? What is the need? So basically, let's suppose Supreme Court has given its judgment and you have not followed. Then what can Supreme Court do? What can Supreme Court do? It's have only contempt of court power to enforce its judgment because you are the person, you have not followed the judgment of Supreme Court and you say, I will not follow. Then what the Supreme Court do, what the High Court do, what the District Court do? Because police not come under the High Court or the Supreme Court, the Judge Court or the District Court. Police came under state government. So Supreme Court, High Court has only power by the contempt of court to enforce its judgment. So basically, to maintain rule of law. This only power has been given to the judiciary and also to maintain independence of judiciary. and also to ensure effective enforcement of judgment of Supreme Court and High Court. Now I think it will be clear. We have discussed what is contempt of court, basically disrespecting judgment of the court or trying to misrepresent. So this will be considered as the under of contempt of court proceeding. Article 129 and Article 215 says about the contempt of court proceeding of the High Court and the Supreme Court of India. So basically, contempt Article 1215 says that High Court can issue the contempt of court proceeding against violation of its judgment and for the judiciary lying in its reason. Article 129 says that High Supreme Court can also issue the contempt of court for its jurisdiction and also for the courts which come under its reason. And this for this Parliament passed the law first by the Contempt of Court Act, and they have made civil contempt and criminal contempt. So basically, civil contempt means if you have willfully disobeyed the judgment of the Supreme Court or the High Court, or if any civil matter and you have not followed the judgment, then it will be considered as the civil contempt, and the punishment will only be a fine. But the Supreme Court also stated Supreme Court not Parliament also gave criminal contempt, and in this criminal contempt, you not if you interrupting the proceedings of the Supreme Court or the High Court or the District Court, then it will be considered as the criminal contempt. Or if you are interrupting with the administrative of the justice, then it will also be considered as the contempt or criminal contempt. And if you also trying to scandalize the authority of the Supreme Court or the High Court or the District Court, then it will also be considered as the contempt of court proceeding. If criminal contempt has been issued against you, then you can send to jail. You have then Supreme Court or High Court can send you a jail or can charge a fine or both can do both. But there is exceptions to contempt of court. That is, if you have speaken and if you have criticized the judgment of the Supreme Court or the High Court or the District Court, which is fair for the public, then no contempt of court proceeding issue against you. And if you are innocent, you don't know that whether it will be counted as the contempt of court or not, then contempt of court will also not initiated against you. Now, why do we need of contempt of court? So basically, because Supreme Court or High Court have only contempt of court power for enforcing their judgment, first, to maintain the law, second, for the independence of judiciary, third. Now, let's read. Often it says that contempt of court proceedings come in conflict with freedom of speech and expression. So how? Basically, criticism of contempt of court. So basically, it often come with conflict with freedom of speech and expression. How? Because if you have said something and you are criticizing judgment, then contempt of court will proceeding will be started against you, whether it is a fair or a not a fair, because it is decided by the Supreme Court or the High Court. Then how will I know that it is the fair or not? Because you should lay down the criteria that the judgment is should be fair or not, at what extent you can criticize judgment. So basically, it is the violation of principle of natural justice. Violation of principle of natural justice. Basically, Supreme Court has issued the contempt of court proceeding against you, and Supreme Court is also the authority which is punish you. So the authority which is issuing contempt of court is also the authority which is going to punish you. How can be a perfect judgment that the same authority is giving the contempt of court also, same authority is giving the contempt of court for not violating the contempt for not violating judgment, and also have power to punish. So it's violating the principle of natural justice. So because this cannot be judged on its own case. And one more thing, that contempt of court is generally issued for the judgment of the court, but it has been seen by various reports that Supreme Court judge and High Court judge have issued contempt of court proceeding on for its own discretionary power, that if you have disrespecting the judge of the Supreme Court, basically not the judgment of the Supreme Court. If you disrespecting the judgment, sorry, if you disrespecting the judgment of the Supreme Court, then it's okay. But if you disrespecting the judge of the Supreme Court, then also contempt of court proceeding started against you. What is the fair that? So basically, judge issue COC for its own reputation, है ना? एक मिनट. हाँ, मेरे 20 जमा थे. भैया 35 रुपए का रेट हो गया. अभी तो दे दो, बाद में ले लेना 5 रुपए. अभी दो, ठीक है. एक भाई भैया से बात कर लो. अरे अभी तो उनसे बात कर लूंगा मैं, आप चिंता ना करो. ठीक है, उनसे 10 रुपए मैं और कैश दे दूंगा. इसी पर ही मार दूं. क्या हुआ? इसी में डाल दूंगा. हाँ हाँ. तो पानी का रेट गैस से क्या लेना देना है? अब मैं भरवा दिया करूंगा, यहीं आता है वो ना, एक सुबह सुबह ई रिक्शा लेके. हाँ आता है. हाँ, उसी से भरवा लिया करूंगा. वो भी तो ऐसे ही पानी देता है. वो टंकी में स्टॉक करके रखते हैं भैया, उनका पता नहीं कि मच्छर भी उसमें हो गए, पता नहीं क्या क्या हो गए. अच्छा अच्छा. बात ये पैसे मिले इसके? ये कभी नहीं देते, ऐसे ही बोलते रहते हैं. ठीक है. हाँ भाई. So we have done criticism of contempt of court now. So basically, court have often applied. So judge issues contempt of court for its own reputation. That is the one another issue. And the another issue is that court have often applied different standard with respect to exercise of contempt of court. So basically, no real, no exact definition of contempt of court that is very vague in nature. So generally misused by the judges and issue against minister and former judges, etc. One another issue, one another issue is that basically contempt, the origin of the contempt of court proceeding is by the British to enforce their law. But in the modern society, there is no need of contempt of court proceeding, because if you are issuing the contempt of court proceedings against any person, then you are violating its freedom of speech and expression. So basically, contempt power originated at colonial time by British to enforce their judgment. But in modern time, no need. But now, no need of contempt of court. What is the another? Because judiciary is the protector of freedom of speech and expression, and judiciary itself issuing the contempt of court against the freedom of speech and expression. How it can be a fair? So basically, if you have, let's suppose, anyone have violated your fundamental right under Article 19, then where you will go? Supreme Court. And Supreme Court is also authority on which, by the contempt of court proceedings, they limits your freedom of speech and expression. That is the same authority which is the protector of the freedom of speech and expression, and same authority which also limits your freedom of speech and expression. So how it can be a fair? So basically, judiciary is protector of freedom of speech and expression, then should restrain from contempt of court. That's the basically mean. Now this is the criticism we have done. Now what is the observation has been made in the various report? What is the observation of COC? Basically, approximately Supreme Court stated that misrepresenting misrepresenting of judgment of Supreme Court. Basically, if Supreme Court has given its judgment and you are representing its judgment wrong, basically you have, the judgment is different and what you have represented it's different, then that is misrepresenting of the judgment of court, can also under contempt of court. Now, the Supreme Court also stated freedom of speech and expression is important for individual, is important, but it should not affect the independence or the respect of the judiciary. So basically, but it should not decrease confidence of people in judiciary. So basically, there should be a need for contempt of court proceedings. And also Supreme Court says court asks for distinguish between fair criticism and contempt, and held that contempt of court cannot issue against fair criticism. So basically, these are the provisions which are associated with the contempt of court proceedings, which we have discussed right now. So what is the proceedings? Let's discuss one more. So what are the proceedings? So basically, contempt of court power has been given to the Supreme Court and the High Court only under the Article 129 and 215. Under Article 129, Supreme Court have the power to issue the contempt of court against any person if they violated the judgment of the Supreme Court, and also can issue contempt of court if they violated the judgment of the court which come under the Supreme Court jurisdiction, that is all across the India. And under Article 215, High Court have also the power to issue the contempt of court against its judgment and also the judgment of the court which come under its reason. Plus, in response to this, Parliament passes Contempt of Court Act 1971, where they uh, give two definitions of contempt, that is civil contempt and the criminal contempt. Basically, civil contempt is that if you willful disobey the reputation, if you will disobey the judgment of the Supreme Court, then on the on the civil matters, then the punishment will be given to you, and the punishment will be fine only. Of the criminal contempt, that is if you interrupting the judicial proceedings, or if you interrupting with the administration of justice, and if you trying to scandalize the authority of the judge, then it can be considered as the criminal contempt. And on the criminal contempt, punishment can be a jail, punishment can be a fine. Now, there is an exception that fair criticism of judgment will not be considered as the contempt of court. And if you are innocent, you don't know that whether a particular matter will be considered as the contempt of court or not, then there is a relaxation provided to you with respect to contempt of court. But what is the need of contempt of court? Basically, the sole power has been given to court by contempt of court proceeding, and to maintain the independence of judiciary and to also ensure the effective enforcement of the judgment of the Supreme Court. Now also, what is the criticism of the contempt of court? Basically, it violates the principle of natural justice, because the same authority which is issuing the contempt of court and also the same authority which is giving the punishment of the contempt of court. So there is a criticism, and the second criticism is that contempt of court has been made by the British colonial era, and so it should not be continue more. But there is a also criticism that no exact definition for the contempt of court, so therefore it uses very vague in nature. And also, judge uses its contempt of court power for its own reputation, not for the Supreme Court judgment or the High Court judgment reputation. So one another criticism is that judiciary is the protector of the fundamental rights. So how can it limit the fundamental right of the citizens by the contempt of court proceedings by not allowing to someone to speak against judgment of the Supreme Court? So Supreme Court also stated that uh, also stated that misrepresenting of judgment will also be considered as the contempt of court. Freedom of speech and expression is important, but it should not decrease the confidence of people in judiciary. Could ask for distinguish between fair criticism and contempt and hold that contempt of court cannot issue against fair criticism. Now we have discussed contempt of court, which has been mentioned under Article 19 of the Constitution, under Article 19(2) of the Constitution, but one more term has been left, that is defamation. So let us discuss once what is the defamation. Now, what do we mean by defamation? Let's discuss one more. Okay. So now what is the defamation? Basically, defamation is to disrespect, to disrepute someone by deliberately making false statement. So basically, defamation is if you are disrespecting any person for making the false allegation on it, then it will be considered as defamation and proceedings can be initiated against you under the defamation. So now, what are the defamation which has been adopted globally? So in other countries, defamation is considered as only civil defamation. That is, defamation is considered as only civil defamation. That is, criticism between two parties. That is, disputing or any disputes between two parties on disputing will be a civil dispute. There is no criminal dispute. But in India, defamation is considered as the criminal offense and as well as also civil offense. So basically, in other countries, defamation considered as only civil offense, not as the criminal offense. But in India, criminal offense and civil offense both can be initiated against you. So this is the basically in India form of defamation case. Now, what are the exceptions? Exception is that if you are criticizing anyone and this criticism is fair, that is fair criticism, then no defamation. And another article says that criticism, criticism which is good for public purpose then no defamation. I think it will be okay. And also, to fair criticism of public servant with respect to official work will not come under defamation. No, this is the defamation. Now, in the case of Subramanian Swamy versus Union of India, Supreme Court stated defamation is valid. So, Supreme Court is stated that defamation is constitutionally valid. Now, let's discuss what is the criticism and the argument in favor of defamation. So, basically, if we talks about criticism, and here we talks about importance. So first, let's read about the importance. So basically, freedom of speech of expression is not absolute, therefore defamation is legal. And also, dignity of individual is also a fundamental right, therefore disrespecting others cannot be fair. And what is the another? So every citizen have right, therefore others cannot violate, therefore defamation, therefore others cannot violate its right. And also, if absence of criminal defamation can make poor people to defamatory act. Now this is the importance. What is the criticism? That is, in globally no criminal defamation. So why are we adopting this? Globally no criticism, no criminal defamation. And also, it also decrease individual to speak freely, and also imposes, that is merely on speaking. How can be it criminal? So these are the basically criticism that we can say that uh, why do not we need Criminal defamation. Civil defamation is okay, but we don't need criminal defamation. So that's why we have given this argument. Now, we have discussed all the ground in detail. Now, let's go and move forward. Article 19B of the Constitution of India. Article 19B. We have discussed Article 19A in detail. Now we are going to discuss Article 19B of the Article 19 1B of the Constitution. 1B of the Constitution.